Welcome to another episode of Legal Talk with Hahn Hahn attorneys here on eRadio. Today I'm chatting to Nirvana Pillay, one of the associate attorneys from Hahn Hahn, and we are talking about the matrimonial systems and their implications. Interesting topic there, Nirvana. Welcome. Hello. How are you?
I'm well, and you, Ian. Thank you so much for having me again. It's always good chatting with you.
Yes, likewise. I'm also well, thanks. Yeah, it's just dealing with the load shedding situations here in South Africa. But yeah, it's just one of those things, eh? But today, our topic is very interesting. The topic that you chose. What are the different types of matrimonial systems recognized here in South Africa according to law?
So in South Africa, we have in community of property, marriages out of community of property with the application of accrual, and marriages out of community of property without the application of accrual.
Okay, and what are the implications of these matrimonial systems?
Right. In terms of in community of property, there will be no antenuptial contract. So the estate of both spouses are joined into one estate with equal share in the joint estate. The joint estate will consist of all assets and liabilities at the date of marriage and during the subsistence of the marriage. Assets which you may receive as an inheritance from a deceased estate are excluded, provided that it will be stipulated in the will of the deceased. The spouses have then equal powers with regard to the management or disposal of assets. These assets are divided equally between the spouses in equal share upon divorce unless otherwise agreed to in terms of a settlement agreement. Then without a community property with the accrual or with the application of the accrual, there will be an antenuptial contract which is concluded before marriage. The estate remains separate with the freedom to use as the parties wish. Assets and debts acquired before marriage remain excluded. And at the time of the dissolution of the parties' marriage, the value of each estate will then be determined by subtracting the end value, which is at the time of dissolution of the marriage, from the commencement value. So the value that you placed in your antenuptial contract. Any assets that were excluded from the accrual when the ANC was concluded are not included in the calculation and are effectively ignored as if they do not exist. The party with the smaller accrual will have an accrual claim against the party with a larger accrual. So this means that the accrual claim is equal to around 50% of the difference between the larger accrual and the smaller accrual. So for example, if the one party started off with 500,000 Rand and the other party started off, say, as well with 500,000 Rand, but party A, their estate grew to 1 million, whereas party B, their estate grew to 1.5 million. Then you would take that difference of 500,000 Rand and divide it by 2. So that would be your 50% that you would obtain. But it is also possible for a spouse to agree that the accrual will operate on another basis other than 50-50. So an agreed percentage between the parties that they stipulate within the ANC. And then you have out of community property without the accrual system. So this will be the same as with the accrual where an antenuptial contract is concluded before marriage. The estate of each couple remains separate with freedom to use as they wish. The assets acquired before marriage still remain excluded, and any increase or decrease in the spouse's estate only affects the relevant spouse. There will be no accrual sharing. And then upon dissolution of the marriage, each spouse retains their estate as at the beginning of the marriage. And so there's no legal duty to share with the other spouse. And also if one party becomes insolvent, it doesn't affect the other spouse.
Okay, and just for clarity, when Nirvana mentions ANC, she's talking about anti-nuptial contract and not the political party. Just to clarify. What is the process of concluding an anti-nuptial contract?
So the parties will decide whether they will be entering into an anti-nuptial contract or ANC, with or without accrual. Should they require guidance, the notary public, who they contact to assist with the drafting and registering of the ANC, will provide them with a detailed explanation regarding the implications of ANC with accrual and without accrual. Then, should the parties choose the application of the accrual system, the parties will be asked to provide a full list of their assets and liabilities in order to determine the starting values that will be included in the ANC. The ANC must then be signed before notary public prior to the date of marriage and registered within 2 months from the date of it being signed before the notary public. The ANC will then be sent for lodgement and ultimately registration at the deeds office.
Okay, and what happens when an anti-nuptial contract was not registered and the parties now want to actually register one?
Okay, well, in terms of Section 21 of the Matrimonial Property Act, spouses may apply to the High Court to change their matrimonial property system governing their marriage. The court will only grant such a request if it's satisfied that there exist sound reasons why the spouse wants to change the matrimonial property system. Secondly, the spouse must give notice to all their creditors. And thirdly, the court must be satisfied that no other person will be prejudiced by the proposed change. But it is quite an expensive process. So you can estimate the cost between 25 and maybe 50,000, depending on the size of your estate, as well as the amount of creditors that you need to contact and inform.
Okay, and what happens in the case of Hindu customary marriages and Muslim customary marriages, Nirvana?
Okay, so spouses married according to Hindu customary law have been regarded as non-compliant with the Marriage Act, and therefore they do not have full recognition. In reality, Hindu spouses conclude 2 marriages. So first, a marriage in terms of Hindu rights, and then secondly, they enter into a common law marriage. However, marriage concluded under the Hindu rights remains a marriage whether legally recognized or not, although you will not receive the protection afforded to you in terms of the Marriage Act, and thus it's always advisable to register your marriage accordingly. The effect of complying with the Marriage Act means that the spouses have legal protection, and in the case of the death, the Interstate Succession Act would then apply. And similarly, in the case of divorce, the same protection would apply. Muslim customary marriages are similar to Hindu marriages in terms of the fact that they do not enjoy full protection of the law. Muslim spouses usually enter into a Muslim marriage under the Muslim law and then enter into another marriage under the Marriage Act or the Civil Union Act.
Okay, and our final question for today's Legal Talk, Nirvana. What is the position in terms of African customary marriages?
So the default matrimonial property system as provided for in the Recognition of Customary Marriages Act is a marriage in communal property. Section 7.2 provides that all monogamous customary marriages entered into after the commencement of the Recognition of Customary Marriages Act, which will be the 15th of November 2000, are automatically in communal property, with the husband and wife having an equal share in the assets and liabilities. The Act provides that the spouses to the monogamous customary marriage may employ the service of a notary public to draft an anti-nuptial contract to govern their matrimonial property system. And then you would once again have the choice of whether you will have the application of the accrual or enter into an ANC without the application of the accrual. Section 7.4a of the Recognition of Customary Marriages Act states that spouses to a marriage entered into before 15 November 2000 may apply to court for leave to change their matrimonial property system of their customary marriage. So this means the court will only grant such a request if it's satisfied that there exist sound reasons why the spouse wants to change the matrimonial property system. They must give notice to their creditors once again, and the court must be satisfied that no other person will be prejudiced by the change. Section 7.6 and 7.4b of the Recognition of Customary Marriages Act also provides that a husband wishing to enter into a second customary marriage must apply to court to approve the contract that will govern the future matrimonial property of the marriage. And they will also have to cite the existing spouse and the future spouse in the proceedings.
And that was Nirvana Pillay from Hahn Hahn Attorneys. Thank you so much for your time and your knowledge. Much appreciated as always.
It's wonderful to speak to you.
Likewise. Thank you so much, Nirvana. Take care.
You too.
Are you or your business in trouble and struggling to find a solution? Call Hahn Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn Hahn Attorneys, Wednesday mornings at 10 on eRadio.